For many years at Cookman Law, we did limited conservatorships for developmentally disabled individuals who are turning 18. Recently, I stopped doing limited conservatorships, and mostly because I just hate going to court. I hate dealing with the court system. And when you do a conservatorship, you're always going through the court system. But I still get a lot of questions about limited conservatorships, and the biggest one really is, does my child need a limited conservatorship in the first place? So I wanted to share some considerations that you should have when you're approaching this topic and thinking about conserving your child. First, I want to give a really brief overview of what a conservatorship actually is. So when you're dealing with somebody with developmental disabilities who's a member of the regional center and they turn 18, they can qualify for what's called a limited conservatorship. And I actually have a video on all about limited conservatorships. I suggest you watch that video. But really, suffice it to say, what we're doing is we're taking the child's ability to do certain things and we're taking them away. And we're allowing the parents to do it for the child. So this is really a big step. It's actually quite invasive. And that's why we're required to go to court to make sure there's a judge who makes sure that this is really the right step for the child, that it's the best thing for the child. Now, this process does go through the court system, and this can really be a pain. It usually takes about 3 to 6 months to finish a conservatorship, depending on the county. And it can be pretty expensive too. So I think everybody should think carefully before they start the conservatorship process. Now, I do know some attorneys who just think it's a slam dunk. Okay, your child's a member of the regional center, they have developmental disabilities, on their 18th birthday, they need a conservatorship. I don't ascribe to that. I think every child is different, and you really need to think through whether a conservatorship accomplishes what you want for them. Now, I do understand there are some children who really do need to be conserved, okay? These children typically, they don't have capacity, they don't understand what's going on, they might really be taken advantage of, and you really need to make the decisions of where they live, what type of education they get, what kind of health care they get. So in those situations, yes, please go ahead and get a conservatorship for your child. Then there's other children who are very high functioning, even though they have developmental disabilities, and they really want to live fully in the community. And with some training and some help, they should be able to do that. So for those children, maybe a limited conservatorship isn't appropriate, and you might want to do supported decision-making instead, which is a good alternative, I think, to limited conservatorships for somebody who is high functioning. And I have a video on supported decision-making that I encourage you to watch. So now what we're really talking about is that gray area. You know, a child who's not that high functioning, but they still have some capacity. Do they need a conservatorship or not? Or maybe they have a developmental disability and some mental health challenges, because keep in mind, you can only get a limited conservatorship for somebody with a developmental disability who's a member of the regional center, not for somebody only with mental health challenges. So these are the folks that I want to talk about, the ones who are kind of in the middle, who might need one, who might not. All right. So one issue that parents really worry about is financial undue influence. They worry, okay, if my child's living in a group home or, in their own apartment, what if somebody comes along and tries to get them to sign up for a credit card or take a lot of money away from them? Then their credit's blown. What happens in that situation? Well, I do want to let you know that once the child turns 18, your money is not attributable to them. They are their own financial entity, basically. Even if they may not be mature, even if you feel a moral obligation towards them, legally, your money is not theirs. So if they get sued, or if some credit card company comes back and says, hey, you charged $50,000 to this credit card for a round the world trip, pay up, then basically the child can say, I don't have the money. You shouldn't have given me the money in the first place, right? And then if the credit card company tries to sue, really they're judgment proof. They really don't have the money. Now, it can be problematic because it can affect their credit score. But then you think, well, is my child really planning on buying a house in the future? Is their credit score really that important? So these are the things to kind of weigh the pros and cons of, protecting your child from financial abuse.
Hey everyone, If you like my mom's video, like and subscribe.
Now, another issue is for medical decision making. Your child might have a big surgery coming up that they don't want to do, or maybe they need shots, once a month, and they're not very cooperative on this. For them, you might want to get a limited conservatorship over their medical decisions so that you can kind of force them to talk to the doctor or, to get the medical care. Now, usually this doesn't work for taking meds or psychotropic drugs, so this is not really that approach. But if you're concerned that your child is going to have a medical emergency, if they're medically fragile, you might want to conserve them just to be prepared for some sort of medical emergency. So now I also have some clients who have children who maybe they're on the autism spectrum and they have some behavioral tics or issues where, they're worried, like if they're going, let's say they're going through the airport and they go through security and their child has an outburst. What's going to happen? Some kids are pretty big nowadays, right? Would the police or the security guards try to restrain them? Will they listen to the parent? And sometimes parents want to conserve their child for an emergency such as that, so they can take out the letters of conservatorship and say, hey, I can speak on behalf of my child, okay? So in those situations, it can make sense to get a limited conservatorship over your child. But one thing I think you should think about is what kind of message does it send to your child if you try to conserve them? Some children might take that to mean that you don't really trust them. You don't think that they're capable of taking steps on their own. And that might enable them to not make good decisions in the future. Maybe they just don't even try. On the other hand, I have encountered some adult children, who are really relieved if their parents get a limited conservatorship over them because they're really worried they're going to make a mistake. And they know that if their parent is taking steps on their behalf, then really, if they make a mistake, it doesn't really count. So children can respond in different ways, but I really suggest that you talk to your child about this as much as you can, as much as they can comprehend, and see if you can come to an agreement with them. So now my last note on this is that courts have become a lot more hesitant towards limited conservatorships recently. I actually had one case where I was doing the special needs planning and another attorney was bringing a limited conservatorship for my client in Santa Clara County. And in that county, the court investigator concluded that the child didn't need a limited conservatorship, even though the child had some pretty severe executive functioning issues and also some mental health challenges. The child presented pretty well, and the court investigator just thought, well, we don't want to limit this child's rights, so we shouldn't grant it. And in that case, the attorney actually had to submit an additional declaration, giving more information about the child and really begging the court to allow the limited conservatorship. And the court did in that case. But a lot of times the courts are trying to push people towards supported decision-making instead of limited conservatorships because they're afraid that the parents might take advantage of the kids if they're conserved, or maybe the kids won't be able to fully exert their independence. So I just want you to be aware of this, that there really is a trend away from limited conservatorships and towards supported decision-making in the court system. So if you do bring a limited conservatorship petition, be prepared to explain exactly why the limited conservatorship is so needed and supported decision-making just won't do. So I suggest that you speak with an attorney who specializes in limited conservatorships if you're considering getting one for your child. Even if you don't move forward with that attorney, they can really help you, talk through what does your child need? What is your child's capacity level? Is this really necessary for your child, and is it a good idea? As we've discussed and as we know, every child is different and we want the very best for our children. So I wish you the best of luck in making this decision.
Hello everyone. If you liked my mom's video, don't forget to like and subscribe. See you all next time.